Baltimore City Council Ways and Means Committee back in session for City Council Bill 22-0235, Ordinance of Estimates for the fiscal year ending June 30, 2023. We are here for the Sheriff's Office. Couple quick introductions, housekeeping rules, then we'll get into it. First, Eric Costello, Councilman from the 11th District, Chair of the Committee. I'm joined to my far right by Council Vice President Sharon Green Middleton, 6th District member of the committee. To my left, Councilman Isaac Yitzi Schleifer, 5th District member of the committee. Councilwoman Odette Ramos, 14th District. Councilman Ryan Dorsey, 3rd District member of the committee. Councilman Zeke Cohen, 1st District. To my immediate right is Marguerite Curran, staff to the committee. On behalf of Mayor Brandon Scott is Nina Themlis and Sophia G. On behalf of Council President Nick Mosby is Nate Poole. Before we get started, I'm going to disclose that I've publicly endorsed in the race for sheriff for his opponent, Sam Cogan. Sheriff, do you have any concerns from a conflict of interest perspective with me chairing this hearing?
No, sir.
Thank you. All right, I'm going to proceed with chairing the hearing in that case. What we're going to do is as follows. I'm going to turn it over to you in a minute, Sheriff. Anyone who's speaking, I'm going to ask that you keep about one hand length away from the microphone. The reason for that is because of folks that are listening at home, they depend on the audio in here. So inevitably someone is going to mess that up. I will politely interrupt you. That's probably going to happen a couple times today, as it's happened during every single agency hearing to date. I'm going to turn it over to the sheriff in a minute or two. Sheriff, I'm going to ask you to first introduce all the members of your team that are with you today. First and last name, position, and if there's a specific division that they head up. I'm then going to ask you to jump into your presentation. I believe, how many slides do we have? Okay, and you all want to present this 10-slide deck?
Yes, sir.
Okay.
30 slides, sir.
30? Yes. Well, we're not. 30 slides in addition to what you presented last time? Yes. All right, you got to use a microphone first.
I don't have one.
Okay. If you could borrow one from the gentleman behind you or the gentleman next to you. Okay, so let's talk about the slide deck. You all presented last time on the specific services within Sheriff's Department, which are 3?
Yes, sir.
Okay. What is this new information that's 30 slides?
This was just discussing. I know that some of the council members had asked questions as to what the sheriff office particularly is doing to try to reduce violent crime. This is just a presentation to show some of the things that the sheriff office is doing to try to reduce violent crime that we've been doing since 2013.
Got it. And when you say this is responsive to some of the council members, are these questions that you heard during the last iteration of this hearing, or are these questions that have been communicated via writing to the sheriff's office? Just public comments that you've heard? Just
presentation to show that, we're trying to do the best we can to reduce violent crime.
Certainly appreciate that, but I want to get back to the core question. You said that this is in response to council member questions. I'm asking if those council member questions came up during the last iteration of this hearing, or if these are questions that you've received individually from council members, or if these are comments that you've heard in the public.
Council members, that questions that the council had, I believe.
At the previous iteration
Yes, sir.
of the hearing?
Yes.
Correct. Okay.
About warrant service and things like that.
All right, hold on one second.
Just budget responses.
Okay, and when was this? This was just provided to the council?
Yes.
And you all have been in touch with the fine folks from Mayor's Office of Government Relations, correct?
No, sir.
Okay, because there's a protocol for presentations for these budget hearings, that they're sent a day in advance of the hearing for that specific agency.
Yes, sir.
So, all right, what we're going to do is I'm going to give you 10 minutes to run through this presentation and to please use that time as you see fit. That's flex time for you all out of respect for the office, and obviously you put some time into this presentation, and
Oh, yes, sir.
obviously you all feel like this is some information the council needs to hear. And by the way, if you're speaking, you can take your mask off if you want.
Yes, sir.
So what I'm going to do is we're not going to go through the service slides that we went through last time. I'm going to turn it over to the sheriff to introduce his team, and then I'm going to give you all 10 minutes sharp to go through whatever you want to go through in the slide deck, and then we're going to turn it over to the council for questions.
Yes, sir.
Everyone's clear on that and comfortable with the ground rules? And for colleagues, before we get started, we are not taking any votes at this session or entertaining any amendments at this session. The committee will be reconvening at a later date and time, which I expect to be in the very immediate future, as in potentially today, most likely tomorrow, to vote the 3 ordinances out of committee. So if there are proposed amendments, I would ask that you are certainly welcome to discuss those in this forum. Please know that we will not be taking a vote on those, and I ask that you see me after this hearing so we can discuss that and make sure that we have had a chance to properly vet those with the mayor's office and the council president's office. Colleagues, is everyone good with that? Okay, Sheriff, floor is yours. 10 minutes, please and thank you.
Yes, sir. Good morning, Mr. Chairman, members of the committee. Of course, I'm Sheriff John Anderson, Sheriff of Baltimore City. With me this morning is Henry Martin, my Chief Deputy, Jason Grooves, Chief of Operations, Missy Ness Brown, Director of Human Resources. I had Sergeant Gerard Martin, the Fugitive Unit, Sergeant Bowles, detailed to the DEA, Sergeant Bell, Domestic Violence, Hakeem Crampton, District Court, Landlord and Tenants Division.
Thank you. And you all have, if you want to jump through the slide deck, you have the clicker? Yep. And you can come up to the podium if you want. Sheriff, and for anyone, again, just to repeat, if you were speaking, you're welcome to take your mask off. And sir, if you could identify yourself and then take it away.
Yes, sir. It's Sergeant Jamal Bowles of the Baltimore City Sheriff Office, assigned to the Special Operations Division of the Sheriff Office. And as I said, this is just a presentation to show that the members of the council as to things that the Sheriff Office has been doing to try to do the best we can to reduce violent crime. As you can see up here, it's a couple of case numbers. These case numbers are generated by the Drug Enforcement Administration, which is assigned case numbers. And I'll just go through briefly with the slide. I'm sorry, briefly with the slide. At the direction of Sheriff John W. Anderson, a full-time sheriff deputy was assigned to the Drug Enforcement Administration, Baltimore District Office, to assist Baltimore City Sheriff Office with investigating numerous drug complaints in 2013. The deputy was assigned to the DEA to reduce violent crime, specifically focusing on violent drug trafficking organizations operating within Baltimore metropolitan area. Furthermore, the deputy is assigned numerous citizen drug complaints, which Sheriff Anderson often receives from the community regarding criminal activities such as narcotics, trafficking, and other crimes. Thus far, the deputy has initiated and participated in numerous investigations that have resulted in the seizure of kilogram quantities of narcotics, firearms, millions in illegal proceeds, to include numerous arrests resulting in state and federal convictions. Due to the success of numerous narcotics investigations conducted by BCSO in conjunction with our local, state, and federal partners, specifically with the DEA, BCSO has additionally assigned an additional full-time deputy to DEA Strike Force Group in 2019, which is comprised of members of the Maryland State Police, Maryland Transportation Authority Police, Maryland Department of Corrections and Public Safety Services, and the DEA, in a continued effort to reduce crime occurring in Baltimore City, Maryland. The deputy assigned to this particular strike force group has statewide authority from MSP, meaning the deputy can make on-view arrests not only in Baltimore City, but also in the neighboring jurisdictions. The deputy is also deputized by DEA and has federal authority to make arrests pertaining to violations of Title 21. This is also in addition to a full-time deputy assigned to the Bureau of Alcohol, Tobacco, and Firearms to better assist BCSO with conducting firearm investigations and assisting BPD with adopting firearms, arrests, and prosecution. BCSO also has 6 full-time deputies assigned to the United States Marshal Service to assist members with BCSO in attempting to service warrants maintained by BCSO, specifically with a focus on wanted subjects identified as repeat violent offenders. Just some statistical data. This year so far, we conducted 52 search warrants, seized 31 firearms, 1 body armor, 13,000 grams of marijuana, 500 grams of psychedelic mushrooms, 28.9 grams of crack cocaine, 28.9 grams of cocaine, 284 grams of crack cocaine, 128 grams of heroin, and over 2,000 grams of fentanyl. 73 grams of methamphetamines, $71,000 seized thus far, and have conducted 2 federal wiretap investigations. I apologize, 1 state wiretap investigation and 1 federal wiretap investigation. 21 arrests so far and pending indictments in federal court. I apologize. In 2021, we conducted 21 search warrants, 7 firearms, 7,000 grams, over 7,000 grams of fentanyl, 8,000 grams of heroin, over 14,000 grams of marijuana, over 18,000 grams of cocaine, 128 grams of crack cocaine, 1 wiretap, and over $3 million in United States currency and jewelry was seized, and to include 1 vehicle, 16 arrests, and 5 federal indictments. In 2020, we conducted 21 search warrants, 7 handguns seized, 9,000 grams of fentanyl, 105 grams of heroin, 1,300 grams of marijuana, 362 grams of cocaine, 28.9 grams of crack cocaine, 48 grams of prescription drugs, over $500,000 in United States currency. 1 wiretap was conducted in 3 vehicles valuing over $130,000, 17 state arrests, and 2 federal indictments. Currently, we have $615,000 in our asset forfeiture account and is in compliance with all DOJ rules and regulations pertaining to that account. We have over 117 pending assets, pending disbursement to BCSO, which is totaling over $4 million. Notable investigations, as I said, we've been participating in with the DEA and other federal agencies, specifically the DEA, since 2013. Just to go over some case background that we've done, we had a 2013 investigation that led to Delaware. We assisted Baltimore Police Department with a homicide investigation that we ultimately helped them solve. And I believe that person was not found guilty of the homicide, but was found guilty of some lesser charges and was sentenced to jail. We seized over 100 grams of crack cocaine and 2 firearms during our portion of the investigation. In 2014, we had a victim come into the sheriff's office and was debriefed for domestic violence. She was in fear of her boyfriend assaulting her. She provided information to BCSO, which led to, it turned into a federal investigation. And that federal investigation showed that drugs was coming from the state of Arizona, and we ultimately seized $110,000, 24,000 grams of marijuana, and 250 grams of crack cocaine. That all spun from a victim of domestic violence coming in and speaking with our deputies and providing that information, and those deputies then taking that information and going further with it, and was able to dismantle this DTO. Unfortunately, there was 2 postal carriers that was also funneling drugs for this DTO, and they were also indicted part of this conspiracy. In 2015, BCSO identified a DTO which operated in the Western District, in the Western District, Northwest District, Central District of Baltimore City. During the investigation, members of BCSO identified an individual who was receiving kilogram quantities of narcotics of heroin from a large-scale DTO based in the state of New York. Furthermore, the DTO was discovered to use luxury downtown hotels to facilitate the drug trafficking, and also utilize a business in the Western District to facilitate drug trafficking. The investigation resulted in 6 arrests to include the New York Source of Supply, the Baltimore DTO leader being arrested, and members of BCSO with the assistance of the Maryland State Police executed federal search warrants, which resulted in the recovery of 2 kilograms of heroin, 2 firearms, cutting agents, and $200,000 in cash, and 6 defendants in this case were charged federally, receiving sentences ranging from 5 to 8 years. Another investigation that we did in 2015, with the assistance of MSP and DEA, initiated a federal wiretap of a DTO operating in the Western District of Baltimore City, Baltimore County, and Howard County, and Carroll County, Maryland. A wiretap investigation revealed the DTO used businesses to conceal their illicit acts. The investigation resulted in over 500 grams of heroin, 123 grams of crack cocaine, 7 firearms, 8 state arrests, 8 federal arrests, and defendants in this case was sentenced from 5 to 25 years in state and federal court. In 2016, we also conducted another federal wiretap with our DEA and state police partners. The leader of the DTO that they received a source of supply from a DTO based in Atlanta, Georgia. Furthermore, the Baltimore DTO leader sourced a violent DTO in Baltimore that operated in the Northwest District. The investigation resulted in a seizure of 700 grams of cocaine, 2,500 grams of heroin, $58,000 in United States currency received. 5 defendants were arrested, with 4 defendants being sentenced to federal prison 5 years, ranging from 5 to 10 years. The investigation also overlapped the investigation conducted by the BPD of a downstream customer, which resulted in over 300 grams of carfentanyl and numerous firearms being recovered, and over $80,000 in U.S. currency. In 2017, BCSO received numerous complaints from citizens in regards to an open-air drug market in and around the 1500 block of North Stricker Street. In 2018, BCSO, with the assistance of DEA and BPD, initiated a federal wiretap of the DTO, which was identified as a violent DTO that operated in the Central, Western, and Northwest District of Baltimore City. The investigation resulted in over 4,000 grams of heroin being seized, 5 firearms seized, over $592,000 in United States currency, over $300,000 in jewelry seized, 1 vehicle valued at $40,000, 17 individuals was arrested, with 11 of those defendants being indicted federally and receiving sentences of 5 to 8 years in federal court. This is just show some of the
Sergeant?
Yes, sir.
You got 1 minute.
Oh, yes, sir. Just to go over, this is some of the drug lines that we saw during the investigation. The outcome of that, in 2018, we also did another investigation that led to $4.5 million and 10 kilos being recovered. Another investigation that spun from an eviction that we seized over 9 kilograms being seized. Another investigation conducted last year was a stash location. You can see the individual bringing drugs into the stash location. Investigation that we just conducted this year, over 22 firearms being seized. And this was just done last week in conjunction with Howard County and Maryland State Police.
Thank you.
Thank you, sir.
Appreciate it. Council Vice, we've been joined by Councilman John Bullock, 9th District, as well as Councilman James Torrance, 7th District. Council Vice President Middleton.
I don't have any questions at this time, but I would like to say that the young gentleman that just spoke, Jamal, how are you? I taught this young man, believe it or not, in middle school. And you have come a very long way. Just so proud of you, and you keep up the good work.
Thank you, ma'am.
Thank you. Councilwoman Ramos.
Thank you, Mr. Chair. Thank you, Sheriff and team, for coming before us today. Really appreciate it. I wanted to go over a few things that came up in a hearing that we had about evictions on January 25th. I remember it because I'm on the committee, but also that's my birthday. We asked a lot of questions about how the sheriff serves the eviction notices. We asked a lot of questions around letting people know when their eviction date is, that kind of thing. And I believe we were promised that things would be changing, and we haven't seen that. So let me be specific, and I know my colleagues have other related questions. So the first question is around the posting of notices for eviction notices. We know that prior to, recently, that the sheriff's office would actually post on the apartment door. Now they're posting on the building door. And we had asked specifically for that to be changed and a photo taken to prove that the eviction notice was actually on the door. And the reason that this is important is because eviction is obviously a very traumatic experience, and it's even more traumatic when you don't even know it's coming because you weren't properly served. So can someone answer that?
Well, with me, I have Akeem Crampton, who is our supervisor over there, and I call it landlord and tenants. And yes, we are involved in the notification processes out of the district court here in the state of Maryland, right? So there is a procedure in place, and there are statutory procedures that we follow out of the district court. And anytime that the deputy arrives at the property in question in the landlord and tenant case, if there's any question, that matter is brought back to the judge in district court, which I believe is Judge Cooper. What we do is we follow the statute, and Akeem will walk you through the processes. Now, once he get finished, there was comments made, I think, by Judge Cooper that says that a lot of things we do, if they have to be changed, he said maybe the General Assembly should take the matters up, because what we do is by statute.
Understood, and obviously we've been working with the General Assembly, but this posting requirement, I believe, is in statute. So if you can explain that would be helpful.
What we could do is anytime that we get in a situation where sheriff's services in a statute, we contact our lawyer over in the Attorney General's office, and basically our AG over there will walk us through each and every step what we should be doing. And we keep that young man over there busy, real busy, right? So, Akeem?
Yes, sir.
He's at the podium.
Yes, my name is Hakeem Crampton. I'm the director of district court. I'm just give a little bit of stats on district court. All right, back in 2021, district court has 21 districts assigned to district court. For the year of 2021, district court, let me make sure I got it right. Okay, no, 2022. We did a total of 740 evictions plus 139 as of today, total of 879. District court also, we served 8,799 writ of summons. Now let's get to the eviction posting. We post a courtesy notice letting the tenants know their eviction date and their time. This is what we post when we get eviction, all right? What Councilman Dorsey was talking about from the AG opinion from 2021, his opinion was we should do it. Yes, we should. But I talked to Judge Cooper, and he said if the city council wanted that to be done, they would have to take that up at the General Assembly. Now, another one.
Sir, can I just interrupt real quick?
Sure.
So that it seems to me that because the practice was already in place and somehow you've not been doing it, I mean, it also seems to me like it's better for the court system and everything else and the tenant that it get posted on the actual door. I'm not understanding what the hesitancy is.
So, also, the court will then issue a criminal summons. The sheriff will notify the tenant by posting the summons on the complainant on the property or mailing to the tenant. It don't state we can have to put it on each individual door. When we go to apartment buildings, they are locked. The deputies tried to pull it open. It stated that we got to post it on a common area. If we can't get in, we post it on the outside door. If we get in, we post it in the common area where the tenants can see it at. And it's been doing that for years.
Well, and I haven't heard of any cases where somebody gets an eviction notice in the mail.
No, eviction notice don't get in the mail. That's rent notice. Rent notices
And
get,
also, aren't you violating people's privacy by putting it in a common area
no,
so that everybody can see?
no. That's not, no.
Yeah, well, we had a commitment that your office would change that practice.
Oh, if the sheriff like to change that, we would be gladly to change that. We have no problem in district court to change that. But also with eviction, they get this, we post this on their door. This is letting them know their eviction date and time. Not eviction, not a rent notice. This is the actual eviction notice date that we post on their door to let them know their eviction date and their time. Now, let's get to the question about why tenants, we don't give tenants their dates. Because we don't know who tenants are when they call our office. Tenants call and pretend that they're landlords. And it happened numerous times that the tenant had canceled their evictions. And the landlord's called us and said, where's the deputy? We'll say, it was canceled. They say, by who? And we give the name and they say, oh, that's the tenant. So we don't know who these people be calling us in our office, asking for eviction dates. We don't do it. That's just like when people call our office for criminal summons that we leave on their door. We don't get that information out because we don't know who we're talking to. And I ran that through Judge Cooper. He said, you're absolutely correct. So that's why when tenants call us, we don't give it out. We have 4 agencies that advocate for the tenants: eviction prevention, eviction assistant, district helpline, and public justice. I send them an eviction list every 2 weeks with the upcoming evictions. It got the dates, the time, address. So that's what
Right, so
they asked
on
us for,
that-
so we give them to them.
Yeah, so that was my second question, was about the posting, the date. But let me just get back to my first question, okay? So the first question about posting on the actual door. You just held up the notice and said, we posted on the door. But earlier you said, no, we don't
No.
post it on the door, we post it in a common area,
no,
or we post it on the door
We
of the
post the
apartment.
eviction dates on their door. On rent notices, on apartments, we get hundreds of them. So we post them in a common area. But when they actually get their eviction date, we post this on their actual door. Not the common areas, not on the front door. We post this on their door. Just letting them know their eviction date.
Yeah, that's not what we're hearing from renters. So that's why this came up, and that we wanted to have a photo taken to be added into
Oh,
the
yes.
file.
When my deputies post this, they send me a photo. They send me a photo. If you want, I can show you a photo. I have it in my phone. Deputies send it to me when they post it on the door.
Right, and so it's going inside the actual door.
Yes, every time we post this eviction date
Right.
with the time and date, the deputies take a picture of it and they send it to me.
Now,
And it's posted on their door.
On the other piece, real quick, and then my colleagues have some follow-ups. On the other piece, which was my second question, is around the eviction date. So I get that you want to refer people to somebody who might be able to help them get out of eviction. But it seems to me like, that's public information. So why is it that you're not telling people? Is it because you're afraid that somebody else is
We don't-
asking for the eviction date?
We don't know
There
who
could be a
we don't know who we're
fraud,
talking to.
or-
We don't know who we're talking to. That's just like with the mayor neighborhood child. When they help out tenants, they have to prove who they are. Send in Maryland ID, all the documents. We don't know who we're talking to on the telephone. I can be my neighbor calling saying I'm so-and-so, wanting to know when they're getting evicted. We don't get that information out. I'm sorry, we just don't, because we don't know who we're talking to.
Right, and so when landlords call, do you give that?
When landlords call, they call and we give them the date, because they are the ones scheduling the dates.
Yeah, and so how do you know that they're the landlord?
How we know they're the landlord?
Yeah, I mean, you
Hang on,
just said that you
hang on,
don't know.
hang on. Everyone, stop. Ma'am, I'm going to ask you to refrain from commenting or laughing while we're conducting the hearing, and for everyone else who's in the public who's joined us today. Thank you.
Okay.
Excuse me. Councilwoman, you have the floor.
Thank you, Mr. Chair. So you had just said that you're not sure who's calling when a tenant asks, but then when the landlord calls, do you get ID from them? How do you know that they're?
So when the landlord calls us, he give us the complaint, a case number and the address. And then once we pull that warrant, we match it up with the case number and the address. And I also talk to district court to try to figure out, is it a way that they can come up with another code or something for landlords and tenants, because tenants have the same information as the landlords.
Right, so, well, you post the eviction date on their door, so why can't you just tell them what the eviction date is if they don't have it because it's not properly posted?
Again, we don't know who we're talking to, ma'am.
I still don't understand what's the difference between a landlord and a tenant when they call.
Because the landlord is the one who's scheduling the eviction. So we the only ones can give them the date. So when they call to get the date, we have to give the date so the landlords can notify the tenant of their eviction date.
Okay, that's it for me right now, Mr. Chair. Thanks. I'll have my colleagues follow up.
Thank you. Councilman Schleifer?
Yeah, before I get into my original question, I guess I want some clarity on that also. I'm a little confused. So if the sign's getting posted on an external door for the whole world to see, what's the difference who's calling? I mean, it could be a neighbor calling, it could be anybody. If you're publicizing it on the door of an apartment building, and anybody who happens to be coming there, whether they live there or they're visiting there, can see, the people in, apartment A are getting, the eviction date is whatever the date is on there. What's the difference who's calling? I mean, it's just really just the same information that's already on that notice.
We don't know who we're talking to when they call our office.
But what's the difference who you're talking to?
We don't give that information out. We don't know who we're talking to on the other end of that phone. It can be anybody on the other end of that phone trying to get information about somebody.
But that's public information,
What's public information?
the eviction date.
The only public information is once they get evicted, it goes public. It goes into the, yes.
It becomes public information the day you post the sign on the door of an apartment building. That makes it public information because it's visible to the public.
Well, it states that we can post on the common area of the doors. And again, we don't know who we're talking to on the other end of that phone. I mean, no disrespect, but you wouldn't want me to give your information out to anybody if they called us, right?
Well, if you're willing to post it on the front door, if you're willing to post it on the front door of the apartment that I live in, I don't see any difference between that and if somebody's calling in, whether it's me or somebody else, asking for what has already been posted in the public.
We just don't give that information over the telephone. We don't know who we're talking to, Council.
Okay, I mean I'm going to move on to my next question, but the last thing I'll just say on that is, once you post something in the public and something's public information, it doesn't really matter who's calling. It's public information, and so if there was confidential information, certainly specific details or how much money rent is owed or any of those details, I'd understand you not wanting to give over personal details. But you've already put that person's eviction date out in the public, and so frankly, I don't see a difference between that and putting it online or somebody calling in and asking for their date and you providing it, whether it's that person or it's a neighbor or it's a landlord. I don't see any difference because you've already made it public.
Okay, that's why we have 4 departments that advocate for the tenants. They have the same information that we have. That's why I faxed them a copy of the eviction list so that when the tenants call them, they can give that information to them.
Right, but you're harming the tenant because if there's an eviction date that's posted publicly, hypothetical, right? You post it on the front door of the apartment complex, and let's say their neighbor next door doesn't like them for whatever reason, okay? And they see that eviction notice and they get home from work before they do. And they say, oh, my neighbor's being evicted in 2 days from now. and they pull down that sign so that their neighbor doesn't even know. Next thing you know, their neighbor's getting evicted. They're not even aware of the eviction.
When they call our office, it states who they need to contact to find out who their eviction date to.
Okay, I don't see what the big secret is. If you're
It's not a
if
secret,
you're making
sir.
it public, I think it's public. But anyways,
not a secret.
My second question was about the. Can you just elaborate a little bit, or maybe if you were presenting about the wiretaps? I saw you said last year you did 1 wiretap, this year 2 wiretaps. Can you just elaborate on? Your agency does wiretaps?
So our agency does not have the capabilities to do the wiretaps. We often, if we do a wiretap, it's going to be through the DEA, Maryland State Police, or Baltimore Police Department that has those capabilities. And so several of those cases stem from evictions. One case in particular, it was an eviction that took place where the deputy went to the eviction and noticed drugs and guns in plain view. At that point, that deputy then calls members of the Special Operations Division, which is several deputies such as myself and others that come out, and then we hold that location, and then we work the case from there. And a lot of times those cases have spun into major federal investigations, but we don't have the capabilities to do actual wiretap ourselves.
Gotcha. So you guys aren't doing the wiretap. You're just saying that there's cases that you guys initiated that led to the wiretap.
Yes, where our deputies are the lead affiants of those investigations. We just don't have the physical means to. So I want to be clear. The deputies are doing the investigation. They are the lead affiants of the wiretap investigations and conducting the investigations. We just don't have the capabilities to facilitate a wiretap at the Baltimore City Sheriff Office. So what we will do is we will contact our local partner, Baltimore Police Department. And in most cases, most of our deputies assigned to the Special Operations Division are already on federal task forces. So those deputies are able to then seek assistance from those federal agencies such as DEA, ATF, and those are the 2 main agencies that we work with to do those type of investigations. And of course, we work with the United States Marshal Service.
Gotcha. Makes sense. So all the information you're given about all the different cases, that's all from these 12 cases from last year?
So yes.
That was just the conglomerate of all
Yes,
that?
yes, sir. And the reason we wanted to do that is because I know, I hope I'm not, we don't put a whole bunch of stuff that we do. We just like the sheriff always says to me that he wants the work to speak for itself, not to necessarily, do a bunch of bragging on things. But I wanted to give the council an outlook as to what we've done since we've been here.
Gotcha. So so you've done 12 cases this year?
We've done, no, so this case, this year we've done 2 major investigations. One was one that's still actively going, one that we just wrapped up within the Southern District of Baltimore City that we just concluded a wiretap. We had over 22 firearms seized thus far, and we're waiting for federal indictments to come.
Gotcha. So what period of time are these 12 cases over?
So that's over since 13. So if you see the number, the GC, those are all DEA case numbers, but 13 through 22. So what we want to do is just try to explain to the council that we've been doing this every year and just picked some cases, but we're doing a lot of cases every year. Just to give a consistent pattern as to, we're consistently working.
Gotcha. So these 12 cases are over the past 9 years?
Yes, sir.
Gotcha. Okay. Thank you for the clarity.
Thank you. All right.
Thank you. We've been joined by Councilman Mark Conway, 4th District. Councilman Torrance.
Thank you, Mr. Chair, Mr. Sheriff. Good to see you again. I just want to ask for a commitment. One is as a follow-up as a committee request on suggested language for the change to the statute. I understand you all have spoken with the judge. You all have an idea what that language should look like. I would like to see what your office would like to put forth as that language so that it'd be clear with the council what you want, and then maybe discussing with the mayor's office a priority in terms of getting that redefined for you.
Yes, sir, we can work on that.
Yes, sir. I just don't want to talk around in circles anymore.
Let me say this.
Appreciate you.
I've been with the sheriff's office since 1972. I had to carry out certain duties dealing with being a sheriff, deputy sheriff. And there's certain duties that we carry out that it pulls at your heartstrings when you got to do it.
Sheriff, a little closer.
You know,
Thank you.
sometimes it hurts you to do it, but you got to carry your duty out, because we are duty bound. We are an extended arm of the court system, may it be the circuit court or district court. Let me tell you a story, and I'm gonna keep my story straight. I'm making short. When I first became sheriff, they still had a death penalty in the state of Maryland. I put 3 guys on death row because the statute says that once a defendant in a murder case, a capital case, they would try another to death penalty. Once that person was found guilty and the judge sentenced them to death, then that person would be rendered over to the sheriff, maybe in Baltimore City or Howard County. And the sheriff would transport that person, the sheriff and his deputies would transport that person over to the Department of Corrections, and that person would be put on death row. However, documents you would get, you would get the death warrant, and you would get a stay automatically. So that person could actually get an appellate process going. I had mothers that told me, Sheriff, don't put my son on death row. Don't kill my son, Sheriff. You know how I felt walking to the elevator with that young man, with his mother hollering and screaming at me, don't kill my son, Sheriff. And my deputies go out there on these landlord and tenant cases, evicting people. We get no pleasure of that, but we must follow the orders of the court. Grant you, as time go on in history, things change. And the General Assembly understands that. And we're willing to work with the council, the General Assembly, the judiciary, to maybe make some changes in these landlord and tenant cases. You know, we're willing to work. We serve the people. I tell my people all the time, we're public servants. So if we got to work with the council and these other tenant advocate groups and the judiciary and our representatives at the General Assembly to try to resolve a lot of these issues, I'm there for it. Thank you.
Thank you, Sheriff. And then I just only have another request, is a follow-up meeting about your asset forfeiture, understanding what your processes are with the forfeiture and how you got there, especially with your federal partners. That's it. But I just want to make sure Nate and Nina got the request for the language. Perfect. Thank you, Sheriff.
Thank you.
Yes, sir.
We've been joined by Councilwoman Danny McCray, 2nd District, member of the committee. Councilman Cohen.
Thank you, Mr. Chair. Thank you, Sheriff and team. And apologies, your name one more time?
Hakeem Crampton.
And Deputy Sheriff?
I'm the director of District Court.
Got it. So you had mentioned that in these cases, you do take photos of the eviction being posted on the tenants' doors. Could you commit to sending the council those photos so that we could have verification that that's happening?
Sure, if you want, I can give y'all my email so I can, when they send it to me, I can email it to y'all, letting y'all know that once they post a eviction notice on their door, they send it to me. I would be glad to email it to y'all.
Okay, so just so I'm totally clear, moving forward, all eviction notices that are posted on tenants' doors will be emailed to the Baltimore City Council?
No, the eviction notice, yes, these right here. Not the rent notice, the eviction notice. It's 2 totally different things.
Hang on. I'm going to just go to Council Vice President Middleton for clarification on the documentation request, and then right back to you, Councilman. Council VP.
Just for clarification, you're going to email them to the committee, and the committee chair dispenses them to the council.
Yes, whoever they want me to email it to.
Photos that
That
was
would be me.
requested from the first district.
Can you get that by call of business today, please?
Sure can.
Excellent, thank you. Councilman Cohen?
Thank you. And so both the documentation that is current, so all the ones that you currently have, and then moving forward, it will be a practice. Just want to get total clarity here to send the notices to Chairman Costello and for him to distribute to the council.
Yes. So whenever the deputy go post these, they would send it to me, and I would email it to the chairman.
Okay, great. And just final point on this, is there a part of the Attorney General's opinion that you all specifically disagree with, or at this point, can we, moving forward, just respect that opinion?
Well, let me say this.
Yes, sir.
The Attorney General's opinion in the eyes of the judiciary, and I know how I believe Judge Cooper feel about it, is that the AG's opinion is an opinion, it's not law. So the AG's opinion basically tried to clarify things, I guess, for the sheriff, or give the sheriff kind of directions. But also, the judge is the, I guess, in a way, the final arbiter if there's a question about us carrying out a duty. That's why we go to the courts for direction. And the judge would say, in this particular matter, Mr. Sheriff, this is my directions and orders to you, how to carry out a particular duty or task.
So, just so I understand, the Attorney General's opinion is not law, is not the interpretation of
It could
the
be
law?
an interpretation of law to give the sheriff guidance, but also the courts are there, the judiciary, and they interpret the law also, and they give directions to the sheriff.
Is there a specific part of that interpretation that you all formally disagree with? Just again, trying to understand.
Well, you know, you don't normally disagree with your lawyers, right? You know, you can ask questions of your lawyer. You say, counselor, what about this? What about that? And the counselor say, well, in your best interest, right? We suggest you do this because, and most often, you follow their directions because if a civil matter come up, they're the ones who want to represent you. And with sheriffs, most often, if there is a monetary piece that has to be paid out, that the state of Maryland, you know, they would have to pay it. So most often, seeing how the state is the one that most often would pay civil liability claims for the sheriff, most often you listen to their directions.
So just for the record, though, the AG's job is to interpret statute from the General Assembly.
Well, the General Assembly, you know, they're like, you know, they're a legislative branch, correct? They make the law.
Make the laws.
Correct. Then you have the courts that rule on the law, right? So the Attorney General, they're there, in my case, they represent me. And if there is a matter to come up involving us carrying out one of our constitutional duties, if there's a question that come up, that's when we go to the Attorney General's office for advice and counsel. And he will basically says, you should do this, 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 this. But the courts may not, in totality, agree with what the Attorney General is saying. Because as you see sometime in court cases, you would have one side make an argument about a particular issue, then the opposing side make an argument about a particular legal issue, then the judge would make the decision. Am I clear?
Yeah, it's just my understanding, though, that the Attorney General's there to interpret the law, not necessarily for your interests, but for the state of Maryland.
Well, mostly when it comes to my case, it's for my interests
Okay.
at my request. But now, I would say, the Attorney General, my rep, isn't here to basically explain their position, right? And I don't want to go too far afield because they're not here to say, this is what we do, especially in reference to the sheriff here in Baltimore City. But most often, in our normal workaday world, what happens if an issue arises, we call our rep in the Attorney General's office, and they will say, most often they'll say, well, let me get back to you, because at that point, I believe my lawyer want to research the statute before he gives me direction. Now, once he gives me direction, then most often we follow his or hers direction. And also, in some cases, we consult with the judges. Sometimes we have to consult based on a number of issues that are presented to us, and before we actually go out and carry out an action for the courts, we go a step further and ask the judge, especially issuing judge, how do you want us to truly proceed in this matter?
Understood. Mr. Chair, I have some more questions on a different line, but I'd be happy to come back in the next round. Just to conclude, just again, for the record, it is my understanding that the Attorney General represents the people of Maryland, not one individual office or party.
Yeah. Such as myself, I represent the people.
Understood.
Also, I'm a state constitutional officer, so just as each of you, you represent the people. We all represent the people. So
right.
What we do, we take in the interest of the people.
Thanks.
Thank you. Councilman Conway.
Thank you, Mr. Chair. Thank you, Sheriff Anderson, for coming today. I had a couple questions for you. I believe I asked your deputies, or began going down this line of questioning at the last hearing, and asked your deputies about the court security service, and particularly with regard to court security officers versus deputy sheriffs. I understand that court security officers have the ability to kind of patrol the court just within that area, whereas deputy sheriffs can kind of act throughout the city. Is that correct?
That's correct. Our court security detail, we refer to them as CSOs.
Got it.
Their primary duties is to provide security for the circuit court of Baltimore City. As you said, the courtrooms, the hallways, at times the streets surrounding the courthouses. At this point, we have three. We had the Cummins Building, we had the Mitchell Building, and we had the Juvenile Justice Facility on Gay Street. Deputy sheriffs, they have law enforcement powers throughout the city of Baltimore, just as a Baltimore City police officer would have.
Right. So they have.
So they
broad
also
policing
provide. They also provide courthouse security also, because one of my constitutional duties is to provide security for the circuit court of Baltimore City, and to carry out that duties, my deputies actually assigned the courtrooms right along with our CSOs for me to carry out that particular constitutional mandate.
Got it. And there is a pay difference between the court security officers and the deputy sheriffs.
I think you said pay difference.
Yeah, we pay deputy sheriffs more than we do.
Correct. We pay deputy sheriffs more than CSOs. Deputy sheriffs state employees.
Got it.
Our CSOs are unclassified city employees, so they're on two different pay scales. But as I speak, we're negotiating, our deputies and even my CSOs, they now have collective bargaining. So we're in the midst of a collective bargaining session for our deputy sheriffs and our CSOs, and I hope that that process will produce a situation where their salaries will be increased.
That's right. How many deputy sheriffs do we currently have performing security at our courts?
Okay, that varies from time to time. Jason, you had a count?
We have 25 deputy sheriffs full-time assigned to security, and we send 6 to 9 daily to assist them in filling their duties.
So it ranges between 25 to 31 is, or you said 6 to 9?
Yes, we have 25 permanently assigned,
25, okay.
and then daily we'll send an additional 6 to 9 depending on what their needs are on that day.
Got it. So between, we're looking at up to 34. And so one of the considerations that I was curious about, have we considered a bailiff system? Have we considered leveraging bailiffs to fulfill that court security function, knowing that we do have, I guess, a shortage for CSOs?
Excuse me.
Well,
The reason why I'm asking that question is our deputy sheriffs do have an opportunity to provide broader broader police functions, as you put it, across the city. They can help in much more. I don't want to say that it's not useful, but more
Well,
important
the,
in urgent areas.
What one remedy could be is that we have a number of CSOs positions that's frozen, right? If we could get those positions unfrozen, then those positions that are frozen, right, we could put them into those courtrooms, and those deputies at that point could be spread out in our field enforcement division. So that could be one remedy also.
How many vacant court security
Frozen.
officer positions? Not frozen, I guess frozen and vacant, but separating the two?
You talking about how many CSOs we have total?
Yes, but separate out the vacant ones so I can understand what we are able to fill today versus ones that we are not able to fill because we are using that frozen salary to backfill elsewhere. What?
Currently, we have 24 CSOs, 30 frozen spots, 8 open, and 60 total. 62 total is what we should have. We have 24.
Okay, thank you. My next line of questioning is with regard to the deputy sheriff division, and so in the budget book it said that the division processes roughly 70,000 court orders annually, and that that includes roughly 1,800 warrants per month. Also noted that you have 66 deputy sheriff positions.
Deputy sheriff positions, we currently have 103 deputies. We have 25 openings, and we have 1 frozen.
Okay. How many folks are working on the warrant service specifically?
We have 6 full-time deputies on the warrant squad.
But I believe, can I add on that? We have 6 full-times, then we have like, I believe, 14, as we call them, part-time warrant people. And basically, what that 14 do is they assist the primary group, such as one initiative that we're working with the city police now. They're getting up start like 4 o'clock in the morning. And that those additional deputies are joining the primary group to go out to execute those warrants. So at any given time, we could have like around 20 folks out there working warrants at any given time.
Okay, so can you just break down the numbers for me again? How many total deputy sheriff positions do we have?
We have 25 openings. We have 103 deputy positions filled, state deputies, and we have 1 frozen.
So 103 filled.
Correct.
And you said 8 open?
We have 25 openings.
25 open. And we have 6 on warrant service full-time.
Correct.
Of those, how many are how many warrants go unserved each month?
Sergeant Martin.
Sergeant Martin, Baltimore City Sheriff's Office. In reference to your question, you asked me how many warrants are unserved each month.
Yes. How many are we unable to serve each month?
We are currently unserving about 45 unserved warrants. In conclusion to your question earlier, we have a total of 6 full-time deputy sheriffs, and we have 4 deputy sheriffs that are full-time due to 2 are out currently, 1 on accident leave and 1 on military leave. In conclusion, we supplement 21 part-time deputies from district court, child support, court security, and domestic violence to go out on our missions, which we go out on Monday through Friday as well as Saturday. So we work 6 days a week, sometimes ranging around from 5 a.m. to about 11 a.m. to serve failure to appear warrants, violation of probation warrants, and failure to comply with home detention warrants, which are to categorize as a misdemeanor and felony warrants.
So you said we have 45, roughly 45 unserved warrants each month?
That is correct. So we had a backlog that we have caught up with. That's why we work the Saturdays to catch up with that, which we are now caught up with due to the pandemic.
Got it. And what is that backlog?
That was the total number that we had to catch up was on around about 120 warrants. That was due to the COVID pandemic, as well as us assisting the United States Marshal Fugitive Task Force. We also was tasked with them as well with other local jurisdictions such as Baltimore City Police, Howard County, Baltimore County to serve out our violent offender warrants.
Okay, so 45 unserved each month. We have 120 warrant backlog.
That we have now caught up with because we now supplement the part-timers on Tuesdays and Thursdays, and we work Saturdays. So we work Tuesdays and Thursdays from 5 a.m. to 8:30 a.m. because we have to send those other deputies to their respective units for court security or their other missions. And we work Saturday mornings from 5 to 11 to catch up with the backlog, which we're up to date with.
And forgive me if I'm getting into the weeds and the numbers. This is important because, as you guys are fully aware, the folks you're serving warrants on can sometimes be our violent offenders. So I'm curious to that effect. For the 120, that backlog, do we know how many are for violent offenders?
Approximately 65 of those are violent offenders, meaning felony warrants such as murder, armed robbery, and handguns, handgun on person vehicle warrants.
Got it. And do we prioritize? How do we prioritize that list?
So we do prioritize those. That's why we're with the task force. Those warrants that we serve with the task force are only felony warrants that we can participate in. So unfortunately, the misdemeanor ones, which we were backlogged on, we have to do within the agency. That's what the Tuesday, Thursday, and Saturdays are for, so that we can catch up with those. It should be noted that on January 31st to February 11th, we had an Operation Washout. That's what the United States Marshals, that was also aired on the news. We participated in that, had a total of 15 arrests, which we led. And those charges include from carjacking, murder, firearm possession, armed robbery, and firearms and drug trafficking.
all which are Baltimore City Sheriff's Office warrants, which are home detention, failure to comply with home detention, violation of probation, and failure to appear.
Got it. Thank you. And then last question on this line. What is our oldest warrant for our violent offenders? Do we have a sense for that? How old is our oldest warrant?
Can you repeat that question again? I'm sorry.
How old is our oldest warrant? I know we're working through a backlog, so how far back does that backlog go?
It ranges. We do have some old warrants that we have made the attempts on. So I've been sergeant since 2020. So since I've been there, we've attempted every warrant. We're still investigating a lot, but to answer your question, we have at least made an attempt to apprehend that individual. We have been unsuccessful with some because, you know, a lot of people have moved. Housing facilities are down now, and just the pandemic virus. So we're actively, like I said, trying to catch up with the violent offenders in which we participate with our other agencies, and as well as parole and probation. They assist us as well with the violation of probation warrants.
Okay, if you could provide that, that'd be really helpful to know.
Yes, I
just
do
so we
have that.
understand the pace at which we're moving through. Thank you, Mr. Chair.
Thank you.
Thank you. Sir, can you provide that to the committee by call of business today?
Yes, sir, I can.
Thank you. Councilman Bullock? Thank you. Councilman Dorsey?
Can somebody just reiterate what that last document is that was requested? So I'm not repetitive here.
It was a request about violent offenders and those with warrants that the Sheriff's Department is supposed to serve, and to understand that backlog, how far it goes back.
Gotcha. Okay, thank you. First of all, there was, I'm sorry, I don't have your name.
Hakeem Crampton.
Mr. Crampton, when you were at the podium before, you said that when a person calls us to ask when their eviction is taking place, they're told where they can call to get that information.
I can't hear you.
At the podium before, the lectern as it may be, you said when a person calls us to ask when their eviction is taking place, they're told where they can call to get that information. Did I get that correctly?
It's on our answer machine. It tells you to call. If you call in to schedule an eviction, it gives you the hours of operations, and it tells you if you want to know your eviction date, it tells you who's to call. And one of the agencies requested us remove them from our answer machine.
Who are the others?
Okay. Public Justice asked us to remove them from our answer machine. So we have eviction prevention through the mayors and children neighborhoods. We have eviction assistance through the state. That's on Guilford Avenue. Then we have district court helpline.
District court what?
Helpline.
And so those, do you know anything about what the process of any of those organizations are as to how they would determine to be able to give that information to anybody?
We provide that information to them.
You provide?
We provide, every 2 weeks, I give them an updated list of evictions, every 2 weeks.
And so until recently, when the Public Justice Center asked you to stop referring people to them, you were providing information to the Public Justice Center every 2 weeks?
Yes, Matt Hill requested us to remove them because they are overwhelmed with calls.
But that same information that you were providing to the Public Justice Center, you say that for reasons of privacy, you can't provide to people calling you directly?
Well, we send it to Public Justice because that's who Public Justice advocates for the tenants. So they request our list of evictions. So when the tenants call them, they will have their eviction date for them.
I mean, I know I have done a lot of work with the Public Justice Center. I respect them, and yes, it's accurate to say that they advocate for tenants, but tenants also advocate for themselves first and foremost. If I, as the tenant, can't get my own information, why would you be giving it to somebody else to advocate on my behalf?
Well, when we send them the list, their name is not on the list. It's their address. So when the tenant called them, they give the address to Public Justice. So their names is not on the list. So the the public don't know who they are because their names is not on the list.
So, to the same point, you can give the public justice centers, public justice center information on an address that's to be evicted, but you can't give it to anybody else?
Well, I know who public justice are. I don't know who these other people calling my office asking for information on.
But the point, I think, is that it's public information. And you're being selective about who you believe should rightfully have access to that information. It's public.
You want me to answer that?
I mean, I'm sitting here perplexed.
Oh yeah, it's public, but we don't, again, when people call our office, we don't know who we are talking to. It could be anybody calling our office to find out information about somebody. We don't give that information over the telephone. That's just like when people call us to ask for warrants, say, hey, do I have a warrant? We're not gonna tell you over the phone, yeah, you got a warrant. You would have to come in, you would have to show us who you are for us to give this information out to you. We just don't give out information to any and anybody.
Excuse me, could I kind of like put a footnote
sir.
in there? As Akeem said, you know, people will call in for other information other than landlord and tenant cases, especially on warrants. They'll say, do you have a warrant for me? A lot of times we say, we can't give over the phone, but if you'll come in and bring, you know, proper credentials or whatever, we'll confirm if we have a warrant for you. If we don't have a warrant for you, of course, as you say, it's public information, but on the other token, suppose there's somebody other than a tenant calling that want to know information about that particular tenant, you know, so that could raise some privacy issues also. You follow me? You know, you could have someone that a neighbor or something that may not like that particular tenant or whatever, and may call us and says, do you have a put out notice for tenant so-and-so, right? We don't know who we're speaking to. We could be speaking to the neighbor next door who don't particularly care for that tenant. And there could be some privacy issues there if we would get that information out to other than the tenant. But again, the tenant could come into the office and says, I like to check on to see if you have any processes from the courts dealing with my case with my landlord.
The internet also doesn't know who a person is, right? I can go to judiciary case search and I can put in a name and look up any court proceeding that has ever occurred related to that person. There's a significant portion of the population in Baltimore City that doesn't have internet access, but may have phone access and should reasonably be able to seek information from the government about actions that the government is going to take against them and get that information from the government. If I can search it online without anybody knowing who I am, why can't the sheriff's office provide it to me?
Well, again, I know that the internet's there, and we all know some folks use the internet for not so good reasons. I'm not going to get into the weeds on that. But what I'm saying is that the person can come in to the sheriff's office, present ID, and we can confirm if we have any particular court documents for them. I believe, by the judiciary using the internet to post certain informations of the courts, that is allowing folks to have access to what's going on in their court system. I agree with you, Councilman. A lot of people, they don't have internet or computers that they can go right to and seek that information. But again, they can come into our office and, again, show us proper identification, and we will, let them know if we have any particular court documents for them.
Just like the sheriff said, I have no problem. If a tenant want to know their eviction date, they can come into the office, show us their ID, letting us know who they are, and I will be gladly to provide them that information. But I can't do it over the telephone because I don't know who I'm talking to. But if they want to come into the office and ask, hey, as I'm scheduled for an eviction and they got their ID, and I look at their ID and I look at the warrant, and if they schedule, I'll be glad to say, yes, you're scheduled for this day and this time.
I'm going to move on from this because this hurts too much. I want to come back to this question about eviction notices. First of all, the paper that was shown is the notice of a specific eviction date that is upcoming. Am I correct? Like a specific date of, what do you say, ejection?
Correct. That's one from the hearing we had in January. That's one of the changes we made, because the law is that the landlord is supposed to mail the tenant the eviction date and then post the property.
Mm-hmm.
And the question was said, well, how do you know the landlord posted the property? Well, they're supposed to sign an affidavit. So in response to that, we also post the property. So this is the third time that they're getting notice. That's an addition.
You're anticipating my question. That's not the first thing that's being posted on a door, is it?
It's a rent notice. The rent notice is being posted on the door. A rent notice and eviction notice is two totally different things.
Okay, so the rent notice, and that's
mailed and posted as well.
And posted by the sheriff's office.
Correct.
Let me iterate on that. They get 3 rent notices. District court send them one, we mail them one, and we post one.
Right, so that first posting the rent notice that you do on the door, there is still disagreement about what door that's supposed to be on. You contend that it's acceptable to be on the common area door, and the Attorney General differs in their opinion.
Well, the judge down at district court, he agreed we can post it on the common area door.
Do you have a written opinion from that judge saying so?
Oh, I can get it for you. Yes. I can get it for you. And it also states, and as read, the people law of Maryland, it states where sheriffs is posted on the property.
Can I jump in real quick? You said you can get it for us, the opinion?
Yeah, I'll call.
Hang on.
Go ahead.
I will. Is it an opinion that you currently have in hand, or it's something that you need to get from someone else?
I met with the judge last Thursday.
Okay, let's get back. Let me repeat my question. Is the opinion something that you physically have in hand, or
No.
is this something that you need to get from someone?
I can get it from the judge.
So what the councilman's asking for is a copy of an opinion that was transmitted to you verbally. He's asking for it in writing. I just want to make sure we're all clear
Okay,
on.
yes, I'll meet with the judge to get that.
Okay. Can you send that request to the judge before call of business today?
I sure can.
Thank you very much,
And
sir.
also,
if-
can I get
if
your-
you could follow up with the committee to confirm that request has formally been made of the judge?
Sure.
Thank you very much, sir.
And can I get your email? You got it? Okay.
Councilman Dorsey.
Thank you, Mr. Chair. Yeah, I mean, just to respond, and thank you, Mr. Chair, for sorting that out, getting the clarification and the expectation set. the Attorney General's opinion, you're correct. It does say must be posted on the property, but it is very explicit in that the entire purpose of the opinion as it is to clarify what is meant by the property. And the entire purpose of the opinion is to clarify that it is not a building in the case of multi-dwelling unit buildings. The entire purpose of the opinion, you cannot read this opinion and not take this away as the purpose, is to clarify that when it says the property, it means specifically the property seeking to be repossessed by the landlord. The common hallway area or the front door common entrance of a building is not the property seeking to be repossessed. It is an individual unit within that building. That is the entire purpose of the Attorney General's opinion, to clarify that. And yet, after seeking this opinion yourself 21 years ago, you have sought to have somebody else provide an opinion to the contrary?
Can I say something? Excuse me.
Hold on, Sheriff Mike.
I'm sorry. Basically, when they posted in the common area, maybe I can clarify it a little bit. When the deputy go out to these large apartment complexes, when they get there, normally the main door is locked, secure. If they can't get in to post the particular apartment and say in question of the landlord-tenant case, then they post in the common area. But if they can get in, then they go up to the door, that single apartment that's in question, and they post. And I believe it says that, this is just something that I remember from the opinion, which could happen from time to time, right? And this is just something for information purposes, right? Not directly what we're talking about if the door's just locked and the deputy can't get in, right? There is something in there that states if the, say the defendant in a case, the tenant, if they put up some barriers where the deputy can't get in, then the deputy, in that case, can post in the common area. But I think what you're talking about is the deputy, if they can get into the building through the door, right, then they should go to that apartment door, post that door. Okay, am I correct? They should have posted that door.
Correct.
And if they can't actually get in to post that particular door, that they post in the common area, then they make a return. It's been a while since I did a return on sheriff's return, so I'm just speaking in theory, okay? Then on all documents that the sheriff served, there is a return on that document notifying the courts how the service was made. And once that return is submitted to the courts, and if a case is called and if service is questioned, then the judge will look at the sheriff's return and see how the service was made. And if there's a question about service, most often at that point, the judge will make a decision if the service was good service or it was bad service. If it's good service, then they proceed on. If it's bad service, then the judge most often would tell the sheriff, go out and you need to make proper service as the courts see.
I think the point of what I just heard is that the Attorney General's opinion does say that it is possible that there are extenuating circumstances under which posting may not be possible. But a locked door is not one of those, right? The paragraph.
I would say this.
Excuse me.
No, excuse me.
No, I have the microphone.
Okay.
Pardon me, Mr. Chair.
Floor is yours, Councilman.
Thank you, Mr. Chair. The paragraph reads, there may be circumstances in which the process server is unavailable despite reasonable and good faith efforts to affix the summons on the door of the individual apartment. For example, if the deputy sheriff encounters physical obstacles beyond the control of the landlord plaintiff. This is following paragraphs that talk about essentially that the service is being done on behalf of the landlord plaintiff, and therefore in collaboration with the landlord plaintiff who owns the property and has access into the common area of the property. That in the interest of doing the constitutional duty to the fullest of the capability, there exists an obligation to utilize that collaboration for the sheriff's office to work with the landlord. And it's my understanding that until sometime in recent history, this was the practice. That even if it wasn't that the landlord was scheduling and arranging with the sheriff's office to be there at the moment that the sheriff's office was to do the posting, that the sheriff's office was given keys in trust by the landlords whose properties they were serving. Did that stop being the case at some point, and why?
I can answer that, Sheriff. Yes, some apartment buildings, leasing office do not give us keys to their building anymore. They don't even give us their code. We call them and let them know that we're there so we can get in. We get no answer. So the question, your answer to your question is no, the landlords do not give us any keys to their property anymore or codes to get inside their building.
I mean, the opinion is pretty clear that that the sheriff's office should be let into the building by the landlord.
But if they don't give us the keys and they don't answer their telephone, how can we get in?
I mean, I guess at a certain point it becomes, why is the sheriff's office doing the bare minimum to notify like that you're going to throw somebody out on the street instead of getting the people who are doing, who are the landlords to let you into the buildings that they own so that you can do something in a humane manner?
Sir, we do call them. Again, when we get there to their property, we call the leasing office. We're called their call box. We get no answer.
And so you go forward in doing this in
posting on the common area.
Yeah, but the opinion says that that's not good enough. It says specifically it says specifically that there needs to be an obstacle beyond the control of.
Councilman, you have the floor.
It says specifically that there needs to be an obstacle beyond the control of the landlord plaintiff. It's totally in the control of a landlord plaintiff to choose to not pick up their phone when you call or to not have adequate staff in order to collaborate with the sheriff's office in order for evictions to proceed in a manner that meets the constitutional standard.
Are you talking about evictions or posting the rent notice?
The same thing, because it both applies. The opinion specifically says that it applies to all parts of the process.
Well, when we give them the eviction date, the landlord, and the time, the landlord meets us there at that time. We tell them to meet us there.
I would say, since you brought it up, the more important part of this process is the initial rent notice. That's the one that, because you are not posting it in the manner that you are constitutionally obligated to, people are missing their court dates because they don't even know that they're happening.
Again, they get 2 in the mail.
But the posting you make is required.
And we also mail one that's required from the sheriff's office.
But the posting you make on the door is
Councilman,
required.
they also get 2 in the mail, so they're getting 3 from us. I mean, well, they're getting 2 from us and 1 from district court.
But the one that you make on the door is required.
So is the one we mail.
And I'm not contesting whether or not things get mailed. I'm here talking about the fact
It
that
get
you're
posted.
not posting it as you're required to on the door.
We post it as on the common area if we cannot get inside the building. Like I said, we notify the landlords, we notify the leasing office, we call them, they don't open the door, so we post it on the common area.
And what the opinion says is that that's not good enough.
That's an opinion.
The opinion of the advisor to entities of the state of Maryland, known as the Attorney General of Maryland, whose opinion you sought specifically to answer this question, and he did. So I want to know why that's not good enough.
That's not a law. That's not a law.
It absolutely is. It is the Attorney General of the state of Maryland telling you this is exactly what the law of the state of Maryland is.
No. No, it's not. That's his opinion. That's not law. And again, when I met with Judge Cooper, he stated if the Attorney General...
I look forward to getting the judge's written...
Can I finish, Chairman?
Yep, and then we're going to go to Sheriff
Okay.
Anderson.
I'm finished.
You said I can finish?
Yes, you have the floor, sir.
Okay. As Judge Cooper said, that if the Attorney General want that to be in law, they need to go to the General Assembly and put it in law. Thank you.
Sheriff?
Councilman, Mr. Chairman, I believe that we can get the letter from Judge Cooper to the committee, and we can move forward. We can work with the committee, and if we got to go to the General Assembly in the next session to try to get a lot of these issues resolved, we're willing to work towards that effort. Thank you.
Thank you. Councilman, you good?
Thank you, Mr. Chair.
Thank you. Council Vice President Middleton, then Ramos.
I guess just for re-clarification, when the council wants to seek, I guess, changes and things, they have to go to the General Assembly, and the sheriff basically answers to the chief judge of the court. But you just stated that you're going to try to help and work to make this change or process a improved process. Is that my understanding?
Yes, but I was just thinking about something else, that unless the change is made specific to Baltimore City, then you may be bringing other jurisdictions to the table.
Okay.
You understand?
Thank you.
Okay.
How would you say your relationship, your partnership is going with the Baltimore City Police Department?
We've always had an excellent relationship with the Baltimore City Police Department. We currently are working on a number of initiatives with the Baltimore City Police Department. I know most recently we had a warrant service initiative that we're working on with them. I know that we're going to be in Fells Point during the summer working with the City Police Department. I know we worked in Federal Hill with the city police department. We worked up around the area, Garrison Boulevard some years ago. We worked in the Broadway, I'd like to say Broadway, Eagle Street area near John Hopkins some years ago. We are currently over in Sandown, Winchester. We're working in that area. We're working with the James Mosier Baseball League, and we were over there last summer, and we're going to be back over there the rest of this summer because the kids and their parents they were having a rough time for the kids to play baseball because they had some wrongdoers over there that was just getting out of control where the parents didn't feel safe bringing their kids down there to play baseball. So again, this year we have secured that area so the kids can play baseball, and we're going to be there the rest of the summer. And we got a very good working relationship with the Baltimore City Police Department.
Okay. And then I guess the other, I know you had mentioned something, you really try to pay attention to privacy, and I guess I just want to know, have there been, someone had mentioned, they can go on websites to get certain things. Has there been an update of, or can someone go on your website to request and get information specifically about really anything, but I guess more specifically about their eviction notice? Can they go on a website to get that information?
My major says no.
Okay. And what's the reason why? Can that be something that can be improved along with other, I guess, websites that are searching for that kind of information or help?
Well, that's something we could very well look at. We could look at maybe other jurisdictions to see what they are doing in that area also. So, we're open to always do things different, better. So a lot of times you don't have to go recreate the wheel. Sometimes you have to do a little research, look around, see what other folks are doing, and a lot of times you can take things what other folks are doing and help you to do better. So there's something that we can definitely look into.
Thank you. It looks like your deputy wants to also respond.
So with that, we don't put the eviction list on our website. So that's another way that they wouldn't be able to get the information on the evictions, because we don't put it on the sheriff website.
So is that something that I guess the General Assembly would have to help you with clarifying to try to get that on your website, and also this property issue on evictions? Would all of that have to go through the General Assembly process?
No, I don't believe so.
So it would be clearly something that you would have to do in-house?
Well, I think if in fact a bill is put into the General Assembly, I feel for sure that a lot of issues could be brought to the table for them to look at, and they would possibly try to come up with the best situations they can come up with.
Thank you for those clarifications. Thank you, Mr. Chair.
Thank you, colleagues. As a reminder, it's 11:43 p.m. We need to recess this hearing by 12 p.m. for the council lunch. And Councilwoman Ramos, so if everyone could please speed up their questions, and the folks at the Sheriff's Department, if you could speed up your responses.
Thank you, Mr. Chair. Just quickly on the eviction date issue. Not every renter is represented by one of the organizations that you had talked about, because we still don't have right to counsel. So I'm not sure if somebody isn't getting their eviction date from you, and they're not getting it from these organizations because they're not represented, or they don't know to call them other than your referral. It's not clear to me how people would get their eviction notice and know when the date is. Because there's, as you said, there's three. There's the rent notice, there's, the notice, the various eviction notices, and then there's the final when they're going to kick them out. So that's what we're trying to just figure out, because these folks don't have representation.
Okay, so you said with the cities, you talking about with the city agency, that is nobody in the city agency?
No, in terms of the renters.
Oh, the
And,
renters.
a renter, at this point, is just frenzy. They don't know what's going on. They don't know when they need to find another place to live.
Well-
This is a horrible, horrible process that I know you all are entangled in, and many of your officers don't want to be in. But at the same time, we need to be able to provide all the information possible to the renter.
Well,
May I say something, Council Lady? You hit it right on the head. We're being caught up in sometime a very crazy system. Not only with landlord and tenants, but a lot of other duties that we are responsible for. And I believe you said that the tenant at certain points of this process doesn't have legal representation, correct?
Correct. There is.
Right.
That is correct.
So, again, that's where if we go to the General Assembly, that's another issue.
It's already been established that we have to have right to counsel. It just hasn't been funded yet.
Okay.
So we're going to get there.
Okay, like you say, you educated me. It just hasn't been funded yet. Okay, so there lies another avenue that could help out in this process, I believe.
We have, actually, at the state level, it hasn't been established yet. It's the city level that we established it. So let me just go to my next question, because obviously we're not going to get anywhere with that question. My next question is about whether or not your officers know if, or deputies know, if the landlord is not properly licensed. Because when they're not properly licensed, they actually shouldn't be going through the eviction, which we're dealing with in the General Assembly also. But it also, to me, is one of those conflicts that you said that, if I understood you correctly, some of the conflicts, if there's a conflict between the landlord and the tenant, you try to bring it back to the court. And it seems to me like if somebody is not properly licensed, which means that they're illegally operating, which means they probably have a property that isn't up to par, which means somebody probably withhold rent because they weren't getting the light bulb fixed and the refrigerator fixed and all of this. Are you taking those back to court, or you're just saying, no, we don't know that it's unlicensed?
Yes. So once the deputy gets there and the tenant said, oh, he's not licensed, what we do is the deputy calls to me back in the office and let me know. I'll call downtown to get it back on the docket and let the judge make that determination. Half of the times the judge tell us, go forward with the eviction. So yes, we do take it back when tenants and landlords have disputes over payment or any sort information like that. We send it back to court that day at 1:15. And piggyback on your first question, when tenants call to ask for help, I help a lot of tenants, give them a lot of information. I contact, I believe her name is Ms. Tammy in the mayor's office of, me and her got a good relationship. I done helped her with a lot of evictions that tenants is getting put out, and I'll make that phone call, say, hey, can you get on the ball with this to try to speed up the process, or I'll hold back evictions while the city is trying to get this tenant some help. So we are helping tenants to avoid from getting evicted.
Thank you. And I'm wondering if on your your written correspondence from Judge Cooper that the chief judge can also weigh in. That would be helpful.
Okay.
Thank you. Councilman Conway.
Thank you, Mr. Chair. I wanted to go back to my previous line of questioning and just further clarify some information around the warrants served. You said there were 120 warrants in our backlog. Does that count warrants that we have attempted but have not actually served? Are there more warrants out there than that 120? Can you just clarify that, please?
So to clarify your answer, served means we actually arrested him or it was closed due to another agency arresting him or the warrant was quashed due to the judge. So the answer that is not correct. So if it's served, it means we physically arrested or by being quashed by a judicial judge or there was another arrest by another agency. So that warrant would be served. So unserved is making an attempt is not being served. That's just making an attempt on the actual warrant service as in the address, but the actual warrant can still be active. So I could kind of elaborate on that. For example, you can have an address, say for example 1512, and we make an attempt on that address. The person no longer lives there. We attempted the address and we notated it and we put it in our system, but the actual warrant and the investigation is still active. So that means it's unserved. We're just still in the process of serving that.
So there are no further unserved warrants outside of that 120 is what you're telling me?
That is correct. We have made attempts on this. I want to make it clear. So served is meaning we actually physically arrested. We physically arrested them.
I just want yes or no, just to clarify.
Yeah, that is correct. That is yes. That is yes to your answer. That we have attempted all the backlog warrants. That does not mean they've been served. That is to answer your question. We've attempted the warrant, so it is still active. But we made a physical attempt to apprehend that individual. Whether or not we were successful, whether they did not live there or something, or moved out of state, is a different scenario. So that to answer your question, that's how warrant services goes.
Do you guys have a warrant control room where you keep your warrants, a warrant control room?
That is correct. We have that in our miles section. That is correct.
And how many unserved warrants are in that warrant control room?
They vary because that was from years ago. So you're talking about from before I was even a sheriff till now. I can get you, I can get you those answers to try to give you a, logistic number.
But it is more than 120.
That is. From those years ago, that is correct. I'm speaking from 2020 when I was a supervisor, so to answer your question.
Okay.
When I was in charge of the unit. Before that, I would have to get those numbers.
I see. So from 2020 when you started till today,
that is correct.
There are only 120 unserved warrants. Everything else has not only we attempted it, but we have served that warrant. That person is now.
That is correct. Right. That we're in the process. Speaking from a couple weeks ago till now, because we get a high volume of warrants. That is correct. What we have is the 120.
Okay. Thank you.
Yes.
And the other question I had was actually Councilwoman Ramos actually got on this a little bit, but with regard to evictions and checking to make sure that folks have a permit to actually have an apartment. Do we check? How do we check? Do we check? Do we cross-check with HCD's website to make sure that these folks have a license?
No.
Why not?
Why we don't do it?
Yeah. Why don't? Because in order to get an eviction, don't you need to have that?
No. When the landlords and them go down to district court is the one who look and see if they have license and so on. We don't do that. So if they don't have a license and the judge issue that warrant, we wouldn't know if they had license or not license, because once they go to court, it's the tenant have to notify the judge while they're in court saying, hey, if they don't have license, then the judge and them will look it up to see if he had a license or not, and then that judge will make that determination to either sign off on that warrant or not sign off on it.
So you're saying the court does it?
Yes, rent court.
Okay, so if we went back into the evictions that we've done over the last 2 years, we would find no one that has been evicted from a property that does not have a license, is what you're telling me?
I couldn't give you an answer to that, because like I said, they does that down in district court. They don't relay that message to us. Only thing they do for us is once the judge sign that warrant, they send it up to us for us to execute it.
So I'm probably taking words out of my colleague's mouth, but this is unsettling, if only because often renters, I've been a renter, I'm no longer a renter, but I can tell you it's incredibly important that I have the opportunity to withhold my payment for rent if a light's not fixed, if a wall's broken, and blah, blah, blah. Anything happens in that household, and if we're not checking that and we're still evicting folks because the only recourse they have is to withhold their rent, that's incredibly unsettling. So
Excuse
me.
if
Also,
we
Mr.
don't,
Chair,
if
can I
we're
follow
not,
up?
if let me just finish. If we're not checking, I don't care what the court does, but if we're using this paperwork to then evict people from their homes, and we're not checking to make sure that this house is up to standard, if they haven't done the basics, lead remediation, whatever the case, I don't know what it may be, but if we're not checking that's a big loophole for slumlords, effectively.
Councilwoman Ram?
Yes.
Can I just follow up on that and say I think I heard a contradiction here, because when I asked the similar question, you'd said that yes, you do check, and that you work with the tenant, and then sometimes you take it back to the court, and then the court goes ahead and decides.
I said once we get there and the tenant says he's not licensed, then we take it back to court that day. That's what I said. If you might have misunderstood what I said if we go do the eviction that day.
Unfortunately, a lot of tenants don't know that that it's not licensed.
Hang on.
I think the sheriff wants to say something.
My belief is, but we can double check this, is that the clerk's office in the district court, I would believe that they would be the entity that would verify if this landlord is licensed before they would even proceed to sit the case in. So we can check that out, see if the clerk's office is the entity, if they're doing that. If they're not doing it, then there's another piece we can put on the table with the General Assembly requiring the clerk's office and the district court to check that out before they even sit that case in before a judge and the rent court.
Councilman Torrance?
I just have an additional committee request because I've had this issue in my district where the judge has seen a person with an actual landlord who did not have a license and still followed through with it. So can you provide that data so we can understand understand impact of the judge's decision? Because what I've heard today from not only you but the committee is that while I understand that the AG's opinion is only advisory, we're still depending on the judiciary to uphold the law in terms of their interpretation. So if we can at least get some data that shows that the judiciary has an issue within itself, we then can work with the chief judges at both the district and the circuit court to figure this out, or even have the evidence to go to the General Assembly to get this actually changed. I just want to put that out there as a request.
Councilman, I totally agree.
Councilwoman Ramos? Good. Colleagues, anyone else? Thank you all. We're now in recess.
Thank you.